You keep saying term limits. There are other presidential qualifications in the Constitution: age,
Yes.
citizenship. There's a separate amendment, the 22nd Amendment, that doesn't permit anyone to run for a second term. We have a history of states disqualifying, not all, but some, of disqualifying candidates who won't be of age if elected. We have a history of at least one state disqualifying someone who wasn't a U.S. citizen.
Right.
Are your arguments limited to Section 3?
Not quite. The question, Justice Sotomayor, is whether the state is violating term limits by adding to or altering the extant qualifications for the presidency in the Constitution. Now,
so you want us to say, I'm wondering why the term limits qualification is important to you.
Because
are you setting up so that if some president runs for a third term, that a state can't disqualify him from the ballot?
Of course a state can disqualify him from the ballot, because that is a qualification that is categorical. It's not defeasible by Congress. So a state is enforcing the Constitution when it says you can't appear on our ballot if you've already served 2 terms as president. The same
if they're underage when elected, and the same if they're not a U.S. citizen.
The same if they're not, the same if they're not a U.S. citizen, for sure. The age is a little more nuanced, because you can imagine a scenario where the person is 34 years old at the time of the election, but he turns 35 before inauguration.
Well, then that would probably come up to us at some point. The state would make a decision and say he's ineligible, and we would have to decide that question then. But my point is, adding qualifications to what term limit is your argument based on? I'm just confused.
Okay. With respect to maybe I'll start with the age example. Mm-hmm. If a state like Colorado says you can't appear on our presidential ballot unless you are 35 years old on the day of the election, that would be a violation of term limits, because there could be a 34-year-old on the day of the election who turns 35 before Inauguration Day. What Colorado has done here, what their Supreme Court has done, is similar, because under Section 3, President Trump needs to qualify during the time that he would hold office. And the Colorado Supreme Court is saying to President Trump, you have to show that you would qualify under Section 3 now, at the time of the election, or at the time that we, the state Supreme Court.
Now I understand.
Just a point of clarification so we're all on the same page. When you say term limits, you mean our decision in the term limits case.
Yes, I'm sorry.
The constitutional provision governing term limits.
Yes, U.S. term limits against Thornton. Maybe I should call it Thornton instead of term limits. I'm sorry.
Does it have something to do with the fact that the particular circumstance that you're talking about can change? Is that what you mean? I'm trying to understand the distinction between the provision in the Constitution that relates to disqualification on the basis of insurrection behavior and these other provisions that Justice Sotomayor points out. They all seem to me to be extant constitutional requirements. But you're drawing a distinction.
Right. I'm drawing a distinction because some of them are categorical.
What do you mean by categorical? Whether or not you are an insurrectionist is or is not categorical?
It is not categorical because Congress can lift the disability by a 2/3 vote.
But why does that change the initial determination of whether or not you fall into the category? I don't understand the fact that you can be excused from having been in the category. Why does that not make it a categorical determination?
Because we don't know whether President Trump will be excused before he's sworn in, if he wins the election, on January 20th, 2025. And a court that is saying that President Trump has to show now, today, that he would qualify under Section 3 is accelerating the deadline that the Constitution provides for him to obtain a waiver from Congress.
But that's by virtue of the hold, right? Hold office. This is
correct. Section 3 bans him only from holding office.
All right, I ask you, now that I have the floor,
yes.
Can I ask you to address your first argument, which is the officer point? Sorry.
Yeah, why don't we?
Could we? Is that okay if we do this and then we go to
Sure.
that?
Sure.
Go ahead. Will there be an opportunity to do officer stuff, or should we?
Absolutely.
I just want to understand. So on this theory, what is the sum total of ways that that Section 3 can be enforced? That somebody out there can say, yes, there's been a former president who engaged or led or participated in an insurrection and so should be disqualified from office, putting aside the officer argument.
Right.
What is the sum total of ways that enforcement can happen?
So the answer to that question is going to depend on what Your Honor thinks of Griffin's case. So if this Court were to affirm the rationale of Griffin's case, then the only way Section 3 could be enforced is through congressional legislation that creates a remedy. So Congress could reinstate the quo warranto provisions that they initially had in the 1870s.
Is that your position?
Yes, because we believe Griffin's case is correctly decided and should be followed.
And how does that fit with a lot of the answers to the questions that we've been given? You said, well, Congress has to have the ability by a 2/3 vote to lift the disqualification.
Right.
But so, too, I would think that provision would be in some tension with what you just said.
There is
because
some,
if Congress has the ability to lift the vote by a 2/3 majority, then surely it can't be right that one house of Congress can do the exact same thing by a simple majority.
Yeah, there certainly is some tension, Justice Kagan, and some commentators have pointed this out. Professor Bode and Professor Paulson criticized Griffin's
Then I
case
must
very
be
sharply.
right.
Well, we don't think this problem is fatal because to us the 2/3 provision that allows Congress to lift a disability is something akin to a pardon power, where Congress, through enforcement legislation, creates a mechanism by which the insurrectionist issue is to be determined by some entity. It could be the legislature. In the case of an elected member of Congress, each house has the ability to judge the qualifications of their members. Or if it's outside the situation of Congress, it would be whatever Congress enacts. So when it was the writs of quo warranto, each federal prosecutor had the authority to bring a quo warranto writ against an incumbent official and seek his ouster from office under Section 3. But it was still subject to that amnesty provision in Section 3 of the 14th Amendment. So we do acknowledge the tension, but we don't think that's an insurmountable obstacle.
I don't even see why there's a tension. If you analogize the lifting by Congress of the disqualification by a 2/3 vote to a pardon, then surely one would not argue that the fact that the president or governor can pardon someone from a criminal conviction or a criminal offense means that the person couldn't be prosecuted in the first place for the criminal offense.
That's right.
Right?
Yes.
So I don't see what the tension is. They're two separate things. Did the person engage in this activity, which is prohibited? And second, even if the person did engage in the activity, are there reasons why the disqualification or should be lifted or the pardon should be granted?
That's right. I mean, if the Court accepts the holding of Griffin's case, that's exactly the regime that we would have.
Yeah, I don't see there's a tension, but also there's a limit on what one can infer from the mere fact that Congress can lift the disqualification. You can't infer from that it is impermissible to have a prior determination that the person did engage in the insurrection. You can't make that inference.
Okay.
It's not
well,
logical.
but I think
what you're doing?
What's in tension is that you would have the exact same actor and say, look, that actor can lift the disqualification by a 2/3 vote. But you're saying only that actor can put the disqualification into effect in the first place, and it can do that by far less than 2/3. It can do that just by a simple majority of one house.
Or it could do that by doing nothing at all, if the holding of Griffin's case is correct, because just congressional inaction would effectively act as
the only thing it takes to have no action is half plus one saying we don't feel like it.
But that's why we tried to characterize our Griffin's case argument the way we did, where we rely on preemption doctrines as well. So
don't you think Griffin's case is also relevant to trying to figure out what the original public meaning of Section 3 of the 14th Amendment is? It's by the Chief Justice of the United States a year after the 14th Amendment. That seems to me highly probative of what the meaning or understanding of that language, otherwise elusive language, is.
I do think it's probative, Justice Kavanaugh. We didn't rely too heavily on the point that you're making, partly because we have this other opinion from Justice Chase in the Jefferson Davis case. So that argument could potentially boomerang on us, which is why we didn't push it very hard in our briefing. But I think Your Honor is right. This is
why don't you finish your sentence?
it is relevant and probative for sure. But I think there is other evidence, too, that might perhaps undercut the usefulness of trying to characterize Griffin's case as completely emblematic of the original understanding.
Now, why don't we move on to the officer point?
Certainly.
And Justice Jackson, I think you...
Yeah, so I had a question about it because you're making a textualist argument. And as I look at Section 3, I see two parts of the first sentence of Section 3. The first is a list of offices that a disqualified person is barred from holding. And the second are specific circumstances that give rise to disqualification. So first, am I right about seeing that there are two different things happening in the first sentence of section? Okay.
For sure.
So are you arguing both in this case or just one? Are you arguing both that the office of the presidency should not be considered one of the barred offices and that a person who previously took the presidential oath is not subject to disqualification?
We are arguing both, Your Honor.
I don't see that in your brief.
Well,
I see a lot of focus on the second, but not on the first.
There is definitely more focus on the second, and we acknowledge that we have a somewhat heavier lift on the first point.
Why? It seems to me that you have a list and president is not on it.
That's certainly an argument in our favor, but they're also, with respect to officer of the United States, that's used repeatedly in the Constitution, in the Commissions Clause, in the Appointments Clause, and also in the Impeachment Clause. And every time it appears, it's used in a way that clearly excludes the
No, I
president.
understand, but that's the second argument. So the first argument is we have a list of offices that a person is barred from holding, right?
Yes.
Under your theory or under the language of, and we see it begins with senator, representative, elector of the president and vice president, and all other civil or military officers.
Offices under the United States.
Offices under the United States.
But
the word president or vice president does not appear specifically in that list. So I guess I'm trying to understand, are you giving up that argument, and if so, why?
No, we're not giving it up at all. You're right. The president and the vice president are not specifically listed. But the Anderson litigants claim that they are encompassed within the meaning of the phrase office under the United States.
And do you agree that the framers would have put such a high and significant and important office, sort of smuggled it in through that catch-all phrase?
We don't agree at all. That's why we're still making the argument that the presidency is excluded from the covered offices that are listed at the beginning of Section 3.
I'm sorry. Your brief says you didn't take a position on that point.
I'm sorry.
And your brief said, I don't have the site, I apologize. You don't affirmatively argue that point, I think is what your brief said.
In the blue brief?
Yes.
Well, we certainly argued it in the reply brief, and I'll have to look at how we phrased it. But we did point out in our opening brief that there are potential issues if this court were to rule on office under, because that phrase appears in other parts of the Constitution, including the Emoluments Clause, the Impeachment Disqualification Clause.
Would we necessarily have to say, I mean, I thought the point was that Section 3 was unique, that there was something happening with Section 3 that could explain why certain offices were left off or whatnot.
Perhaps, but there are also implications from other parts of the Constitution which really help us on the officer of the United States argument, in that second part of Section 3, but somewhat cut against us when it comes to office under the United States. And the Anderson litigants point this out in footnote 9 in the red brief, where they say if this court were to say the presidency is an excluded office under the United States, that could imply, for example, the president is not covered by the emoluments.
Mr. Mitchell,
yes.
Stepping back on this, a lot hinges on the difference between, in your argument, between the term office and officer.
Yes.
And I guess I'm wondering, what theory do you have from an original understanding or a textualist perspective why those two terms so closely related would carry such different weight?
Because it's clear from the constitutional text that there are officers that do not hold offices under the United States. For example, the Speaker of the House and the President pro tempore, they're described as officers in Article 1 who are chosen by the legislature. They also have to be officers if they're able to be covered by the Presidential Succession Act, because under the Constitution, only officers can serve when there's a vacancy in both the presidency and the vice presidency. So they're officers, but they're not offices under the United States because of the Incompatibility Clause, which says that if you're a member of Congress, you cannot simultaneously hold an office under the United States. So that provision of the Constitution clearly demonstrates that members of Congress can't hold offices.
I appreciate that response. Is there anything in the original drafting history discussion that you think illuminates why that distinction would carry such profound weight?
Not of which we're aware. So these are textual inferences that we're drawing from constitutional structure, intratextualist analysis.
Yeah.
But we aren't relying necessarily on the thought processes of the people who drafted these provisions because they're unknowable, but even if they were knowable, we're not sure they would be relevant in any event because this language, especially in Section 3, was enacted as a compromise. There were certainly radical Republicans who wanted to go much further. If you look at some of the earlier drafts that were proposed, some people wanted to ban all insurrectionists from holding office, regardless of whether they previously swore an oath. Some people wanted to go further and ban them even from voting.
Thank you. Thank you, counsel. I just have one very technical question. The statute in 1870, if it were still in effect, would require you to modify your arguments slightly. It was repealed, as you say, in 1948. I tried to find it, but I couldn't. Do you know why it was repealed?
No, we don't know why. It looks like it was done as part of a reorganization of the U.S. Code. So it doesn't appear there was any policy motivation behind that decision. I think a lot of things got repealed during this 1948 decisions that were made.
Okay. Justice Thomas, anything further? Justice Alito?
Is there any history of states using Section 3 as a way to bar federal office holders?
Not that I'm aware, Justice Alito, because of Griffin's case. I mean, Griffin's case has been the law. I shouldn't say that it's been the law because it was just a circuit court decision, but that has been the settled understanding of Section 3 since 1870 when it was decided.
Thank you.
Justice Sotomayor?
I just want to pin down your principal argument on Section 3. You argue that even though the president may or may not qualify, presidency may or may not qualify as an office under the United States, your principal argument is that the president is not an officer of the United States, correct?
Yeah, I would say it a little more forcefully than what Your Honor just described. We believe the presidency is excluded from office under the United States, but the argument we have that he's excluded the president as an officer of the United States is the stronger of the two textually and has fewer implications for other constitutions.
Bit of a gerrymandered rule, isn't it, designed to benefit only your client?
I certainly wouldn't call it gerrymander. That implies nefarious intent.
Well, you didn't make it up. I know some scholars have been discussing it, but just so we're clear, under that reading, only the petitioner is disqualified because virtually every other president except Washington has taken an oath to support the Constitution, correct?
That's right. Every president, to our knowledge, every other president. John Adams might also be excluded because he took the oath as a vice president, which is not an officer. But yes, President Biden would certainly be covered. He took the oath as a member of Congress, and that's true of every previous president.
Would that be true if we were to hold more narrowly in a reversal that it's not Section 3 that's at issue, but Thornton and others as to whether Section 3 can be enforced by states against the president?
That would extend to every presidential candidate, not
exactly,
just our
not just
to
yours.
Yes.
Okay. Thank you.
Justice Kagan?
And if I could just understand, I mean, given that you say you don't have a lot of evidence that the founding or the generation that we're looking at is really thinking about office versus officer of the United States, I mean, it would suggest that we should ask, is that a rule a sensible one? You know, if they had thought about it, what reason would they have given for that rule? And it does seem as though there's no particular reason, and you can think of lots of reasons for the contrary,
right,
to say that the only people who have engaged in insurrection who are not disqualified from office are presidents who have not held high office before. Why would that rule exist?
I don't think there is a good rationale, given that this was compromise legislation. And sometimes this happens with statutory compromises and even constitutional compromises. There's an agreed-upon set of words that can pass both houses of Congress. But different legislators may have had goals and motivations. They didn't all get their way. In a compromise, everyone goes away miserable. But this was the text that was settled upon. And it does seem odd that President Trump would fall through the cracks, in a sense. But if officer of the United States means appointed officials, there's just no way he can be covered under Section 3. The Court would have to reject our officer argument to get to that point.
And is there any better reason, if you go to the office argument that Justice Jackson was suggesting, is there any better reason for saying that an insurrectionist cannot hold the whole panoply of offices in the United States, but we're perfectly fine with that insurrectionist being president?
I think that's an even tougher argument for us to make as a policy matter, because one would think of all offices, the presidency would be the one you'd want to keep out the Confederate insurrectionists. That's the commander-in-chief of the Army. So, again, that's why we're leaning more on the officer of argument than the office under. We're not conceding office under, but we definitely have the stronger textual case and structural case on officer of the United States.
Thank you.
Thanks.